5 states have property tax laws that can quietly reduce home equity for senior homeowners by $4,000 or more each year. Most seniors are unaware of this until they receive a notice in the mail or discover a problem with their deed. This is not a standard property tax issue. It is a legal mechanism rooted in state and county tax codes that has been operating for decades. A Supreme Court ruling in 2023 addressed part of the problem, but significant gaps remain in these 5 states. In 2 of them, the situation is expected to become more challenging this year. You may have spent 30 or 40 years paying off your home. Your name is on the deed. The mortgage is paid. It is reasonable to assume that the equity in that home belongs entirely to you. However, the rules governing that equity are not established in federal law. They are written county by county in state tax statutes, many of which were created long before most current homeowners were born. In the 5 states covered in this video, those laws still allow the government or a private investor operating through government tax sale systems to recover significant portions of equity that homeowners spent their working lives building. There is one document available at a county or town office, typically costing under $75, that can help stop the most damaging version of this mechanism in 4 of the 5 states discussed here. I will explain what it is before the end of this video, but first it is important to understand which states still have these rules and why seniors with paid-off homes face the greatest exposure. These laws do not disproportionately affect homeowners who are struggling. They tend to affect those with the most equity. Seniors who have done everything financially right can face the largest losses. Let us begin with the case that drew national attention to this issue. Geraldine Tyler, a 94-year-old widow, owned a 1-bedroom condominium in Hennepin County, Minnesota. She fell behind on her property taxes. The total owed, including penalties and interest, came to approximately $15,000. Hennepin County seized the property, sold it for $40,000, kept every dollar, and returned nothing to Geraldine Tyler. The county kept $25,000 of equity she had built over decades and described this as lawful under Minnesota statutes. For years, courts in Minnesota and several other states permitted this practice. The legal reasoning was that once a homeowner falls behind on taxes, they forfeit the entire property, not merely the unpaid tax amount. Under that interpretation, a home worth $400,000 with $10,000 in unpaid taxes could be taken in full, with all $390,000 in equity going to the government. I'm Nancy, and you are watching Senior USA Guide. Geraldine Tyler challenged that reasoning in court. In May 2023, the United States Supreme Court ruled unanimously in Tyler v. Hennepin County that this practice violates the Takings Clause of the Fifth Amendment. The Constitution prohibits the government from taking private property without just compensation. Keeping $25,000 in equity to satisfy a $15,000 tax debt does not meet that standard. However, there is an important limitation to that ruling that most news coverage did not fully explain. The Supreme Court did not eliminate property tax sales. It only established that the surplus equity above the tax debt must be returned to the homeowner. The seizure can still proceed, the auction can still occur, the home can still be lost. The only change is that the county must return what remains after the debt is satisfied, and that is where a new set of problems begins. In Minnesota and the 4 other states discussed here, the rules governing how that surplus is calculated, who receives notice, how long they have to claim it, and what fees are deducted beforehand are still being shaped by state and county procedures. Some counties deduct administrative fees of 15 to 25% before sending the surplus. Others require a separate court filing to access it. If a homeowner misses the filing window, which can be as short as 90 days, the surplus can revert to the county. The Supreme Court ended the most extreme form of equity loss. It did not eliminate equity loss entirely. A $4,000 reduction from fees, missed deadlines, and procedural requirements is a documented outcome in tax sales across these 5 states, even after Tyler. Minnesota itself amended its tax forfeiture statute in 2024 to comply with the Tyler decision. Surplus funds are now held in a state account, and former owners may file a claim within a defined window. However, the claim form is not automatically sent to the former owner. The county is required to send notice, but it goes to the address on record. For an estate in probate or a senior who has relocated to assisted living, that is often no longer a current address. The notice is mailed, the deadline passes, and the surplus remains with the state. This pattern repeats across all 5 states. Federal law closed the primary avenue for equity loss. State procedures left secondary avenues open. The people who navigate those procedures effectively are largely investors who understand the system. The seniors whose equity is sitting in escrow typically do not know it exists. A brief call to your county auditor asking whether your name appears on any surplus list from a tax sale in the past 2 years addresses this issue in Minnesota. It is a call almost no one makes because almost no one knows it is necessary. Nebraska had one of the more severe equity loss mechanisms in the country before Tyler. The state used a tax certificate sale system that allowed private investors to purchase a tax lien, hold it for 3 years, and then file for a tax deed transferring the full property to the investor. The original homeowner could redeem the property during that 3-year period by paying back taxes plus interest at a statutory rate of 14%. A $3,000 tax debt could therefore exceed $4,500 before the redemption window closed. In one documented case from the late 2010s, a Nebraska homeowner lost a property worth nearly $200,000 over a tax debt of less than $6,000. The investor received all of the equity. The homeowner received nothing. After Tyler, Nebraska updated its rules to require surplus return. However, the certificate sale mechanism remains in use. Investors still purchase tax certificates and collect statutory interest. A senior homeowner who falls behind on taxes still faces a redemption clock from the moment the delinquency begins. The change is that if redemption fails and the property transfers, the investor is now required to pay the surplus to the former owner. The calculation of that surplus, however, is where the $4,000 figure appears. Nebraska statute allows the county and the certificate holder to deduct what are called recoverable costs from the surplus before it is distributed. These include attorney fees, title search fees, recording fees, and statutory interest accrued during the redemption period. In most Nebraska counties, those deductions average between $3,500 and $4,500 per case. A senior owed $20,000 in equity surplus may receive $16,000 or less after deductions. That is not prohibited under the Tyler ruling, which does not bar reasonable administrative fees. But for a senior on a fixed income, $4,000 in procedural costs can represent the difference between in-home care and a state nursing facility. The practical protection in Nebraska is knowing the process before it begins. The state requires the certificate holder to send notices at multiple stages, but those notices are written in legal language that most homeowners do not parse easily. They can appear to be routine correspondence and get discarded. The redemption window closes, the deed transfers, and the equity is gone. A licensed real estate attorney in Nebraska at the typical hourly rate of $250 to $350 can review those notices and advise on risk in approximately 15 minutes. That consultation cost can prevent the $4,000 surplus loss and, in some cases, the full equity loss if the redemption deadline has not yet passed. Nebraska also has a homestead exemption specifically designed for property owners over 65 with limited income. It reduces the assessed value of the home, or in some county programs, defers the property tax bill entirely until the property is sold or transferred. The deferred amount becomes a lien on the property, but it sits behind any first mortgage and does not accrue at the higher statutory tax rate. A senior who qualifies and applies can avoid the certificate sale process entirely and preserve the equity in the home. The homestead application is filed with the county assessor at no cost in most counties and can typically be completed in a single visit. Very few eligible Nebraska seniors use this program. Most are not told it exists. Their adult children are often unaware. Their tax preparers may not know either. The county assessor has the information but is not required to offer it proactively. The application sits unused while certificate sales continue. In New Jersey, the mechanism is different, but the potential equity loss is greater. New Jersey consistently carries among the highest effective property tax rates in the country. The average homeowner in counties such as Bergen, Essex, and Union pays between $12,000 and $18,000 annually in property taxes on a single-family home. For a senior whose mortgage has been paid off for decades, that bill is often the largest expense remaining in retirement. When a senior in one of those counties falls behind on taxes, New Jersey runs what is called a tax lien sale, similar to Nebraska, but with a notable distinction. The interest rate on a delinquent tax lien in New Jersey can reach 18%, plus a 6% penalty on the original balance. A $5,000 property tax shortfall can therefore grow to over $6,500 within 1 year and to over $10,000 within 3 years. Beyond the interest accumulation, New Jersey has a separate concern called the abandonment doctrine. Under state statute, if a property is deemed abandoned by the municipality, the lien holder may file an expedited foreclosure action that compresses the redemption window from 2 years to as little as 45 days. The definition of abandonment is imprecise. A senior who moves to assisted living and leaves a home vacant for 90 days while the family considers next steps can have the property declared abandoned by a code enforcement officer, accelerating the foreclosure timeline significantly. In a typical New Jersey tax foreclosure on a paid-off senior home, the surplus owed after Tyler can run between $20,000 and $50,000. Deductions allowed under New Jersey statute include attorney fees that in expedited foreclosure cases frequently run between $3,000 and $4,000 per case, plus lien interest, the statutory penalty, and the municipal administrative fee. The $4,000 equity loss is a predictable outcome in New Jersey cases. The most effective protection in New Jersey is filing before any tax delinquency begins. New Jersey has a program called the Senior Freeze, formerly the Property Tax Reimbursement Program, available to homeowners over 65 whose household income falls below the annual threshold. That threshold is updated yearly by the Division of Taxation, so it should be verified before applying. The Senior Freeze does not eliminate the property tax bill. It fixes the bill at the level it was in the year the homeowner first qualifies, and the state reimburses the difference for any increases in subsequent years. A senior whose tax bill rises from $12,000 to $15,000 over 5 years receives a reimbursement from the state for the $3,000 difference each year. The Senior Freeze application is filed with the New Jersey Division of Taxation with no filing fee. The program requires annual renewal. Missing a single year resets the freeze at the new, higher base amount, which means a senior who qualified at $12,000 and fails to refile 3 years later will have the freeze reset at a rate that may be $2,000 higher. There is also a structural difficulty. The state pays the reimbursement, not the municipality. The municipality still bills the full amount each year. The senior pays the full bill and waits for the state to send the difference. For a senior on a fixed income who cannot pay the higher amount up front, the program is practically difficult to use despite its value on paper. A New Jersey elder law attorney at the typical rate of $300 to $450 per hour can review tax history and senior freeze eligibility in a single consultation at a cost that is generally recovered within the first year of correctly filed applications. Illinois had, before Tyler, one of the most aggressive tax sale systems in the country. The state used a combined certificate and deed sale structure in which investors could acquire tax certificates, accrue interest at rates that ran into the high double digits annually in some counties, and convert those certificates into full property deeds after the redemption period ended. Cook County, which includes Chicago and represents the majority of Illinois property values, was where the most documented cases occurred. Illinois homeowners lost properties worth between $150,000 and $400,000 over tax debts as small as $4,000. Investors collected the full property value. Homeowners received nothing. After Tyler, Illinois revised its tax code to require surplus return, but homeowner advocates have identified gaps in the revision. The statute allows the certificate holder to recover collection costs, attorney fees, and statutory interest before the surplus is paid. In Cook County, average deductions in post-Tyler cases run between $3,800 and $5,200. A senior owed $30,000 in surplus may receive approximately $25,000 after deductions. The protective option in Illinois is the Senior Citizens Homestead Exemption, available to homeowners over 65 who use the property as their primary residence. It reduces the equalized assessed value of the home by an amount that varies between Cook County and the rest of the state. Tax savings typically run between $400 and $700 per year, depending on local tax rates. A more substantial protection is the Senior Citizens Real Estate Tax Deferral Program. Under this program, an Illinois homeowner over 65 with household income below the annual cap may defer property tax payments entirely. The deferred amount becomes a lien on the property at a low statutory simple interest rate, paid off when the property is sold or transferred. The lien sits behind any first mortgage but ahead of unsecured creditors. A senior who qualifies and uses the deferral never falls behind on taxes, never enters a tax sale, and never loses equity to surplus deductions. The deferral application is filed with the county treasurer early in the year, typically at no cost. Very few eligible Illinois seniors use it, largely because the program is not widely known, and many seniors associate deferred taxes with complications for their heirs. In practice, the deferred lien at a low statutory rate is far less costly than the higher interest charged on a delinquent tax lien, and it pays off cleanly at sale or inheritance without penalties. One additional Illinois item worth noting: Cook County has a separate disabled veteran standard homestead exemption that can significantly reduce assessed value for veterans with a service-connected disability rating above a defined threshold. This exemption is commonly transferable to a surviving spouse, but it requires annual recertification with the county assessor in many cases. The recertification form is mailed to the address on record, which means the same address change problem present in Minnesota can result in a lost exemption worth thousands of dollars annually. A licensed Illinois elder law or property tax attorney can review eligibility for all three programs in a single consultation, the cost of which is typically recovered within the first year of correctly filed exemptions and deferrals. Massachusetts is the most active state on this list because the equity-related tax issue there is currently developing. The state has a long-standing property tax limitation statute called Proposition 212, which caps annual property tax increases at 2.5% plus growth from new construction. For decades, the cap provided meaningful protection for homeowners against rapid assessment increases. In recent years, however, a number of Massachusetts municipalities have pursued a mechanism called an override vote, which is a ballot question asking local voters for permission to raise property taxes above the cap to fund a specific project, often a school, public safety facility, or infrastructure repair. Override votes in several Massachusetts municipalities have received majority approval in recent years. For a senior on a fixed income in a town where an override passes, the tax bill can rise by $1,000 to $4,000 per year. This is not equity loss in the Tyler sense. It is a gradual reduction in retained income caused by rising tax bills that the affected senior may be in the minority in opposing. There is also a separate concern that has begun to receive attention. Several Massachusetts municipalities have begun discussing a property tax surcharge based on the appreciated value of a home above its original purchase price. This type of mechanism is being studied in connection with similar proposals in other jurisdictions. None have passed in Massachusetts as of early 2026, but the discussions are taking place in town meetings and legislative committees, and homeowner advocacy groups are tracking the proposals. If such a measure were adopted in even one Massachusetts municipality, it would establish a precedent that other towns could follow. A senior who purchased a home for $150,000 decades ago and watched it appreciate to $700,000 would face a tax on $550,000 of unrealized appreciation. At even a 1% rate, that amounts to $5,500 per year, due in cash on equity that the senior has not converted to income. The primary protective filing in Massachusetts is the Senior Circuit Breaker Tax Credit, available to homeowners over 65 whose property tax bill exceeds a defined percentage of annual income. The credit is capped at a level that updates each year and is filed with the Massachusetts Department of Revenue as part of the annual state tax return. There is no application fee. The credit is refundable, meaning that if the senior owes no state income tax, the credit is paid out as a check. The additional filing is the local property tax exemption for seniors over 65, called Clause 41, available in most Massachusetts municipalities. The amount varies by town, typically ranging from several hundred to a few $1,000s per year. The application is filed annually with the local Board of Assessors, generally at no cost. Together, the circuit breaker credit and the Clause 41 exemption can offset between $2,500 and $4,400 of property tax per year. Now to the filing I mentioned at the beginning. There is one document available at a county or town office, typically costing under $75, that helps stop the most damaging equity loss mechanism in 4 of the 5 states discussed here. That document is a homestead declaration. In Massachusetts, it is the Declaration of Homestead. In Illinois, it is the Senior Citizens Homestead Exemption. In Minnesota, it is the Homestead Classification. In Nebraska, it is the Homestead Exemption. New Jersey is the only state on this list without an equivalent statutory homestead protection covering the same scope. A homestead declaration designates the property as your primary residence and, in most states, protects a portion of the equity from creditors and forced sale. In Massachusetts, the protection commonly extends into the hundreds of thousands of dollars. In Minnesota, it covers a substantial amount of equity for a primary residence on a small lot. Filing fees in most counties run between $35 and $75. Here are 5 steps to consider this week. First, determine whether your state is among those discussed. If you live in Minnesota, Nebraska, New Jersey, Illinois, or Massachusetts, your exposure is highest. In other states, equivalent protective filings exist under different names, and the senior homestead exemption is the most common starting point. A licensed real estate attorney or county assessor can confirm eligibility. Second, file the homestead declaration in your county or town. For most seniors in the 4 eligible states, this is the single highest value filing available. It is a one-time process in most jurisdictions and typically carries through to a surviving spouse. Third, request a copy of your most recent property tax assessment from the county assessor and compare the assessed value to recent comparable sales in your area. If the assessed value is higher than market value, consider filing an abatement application. There is typically no filing fee, and a successful abatement commonly reduces the annual tax bill by $400 to $100 to $200. Fourth, ask whether your state offers a senior tax deferral program. Illinois, Nebraska, and several other states allow seniors over 65 to defer property taxes, with the deferred amount becoming a lien at low statutory interest, paid off at sale or inheritance. The deferral can protect the senior during retirement and reduce the risk of a forced sale for heirs. Fifth, schedule a consultation with a licensed elder law or real estate attorney in your state. The typical fee is between $250 and $450 per hour. In a single meeting, an attorney can cover homestead filing, tax deferral eligibility, surplus claim procedures from any prior tax sale, and estate planning mechanisms for protecting equity in case of incapacity. One consultation commonly recovers more than its cost in the first year of correctly filed exemptions. The underlying pattern across all 5 states is the same. Equity is not lost in a single transaction. It is reduced gradually through fees, deductions, and missed filings over time. The response is a set of small administrative steps, most costing under $100, that together protect against the $4,000 or more that would otherwise be absorbed by procedural costs. Subscribe to Senior USA Guide for more information on protecting what you have worked to build.